In the last module, we covered what AI is and where it came from. Now we need to talk about who built it. You would not sign a contract without knowing the other party. The same principle applies here. The companies behind these tools have investors, competitive pressures, and ideological positions. And those affect the product you use, the price you pay, and what happens to your data. This module covers the builders, the tools they made, and what all of it means for you as a South African legal practitioner. Before you adopt any AI tool, free or paid, there are 3 things you need to know about the company behind it. First, who owns it? The ownership structure tells you about the incentives. A nonprofit has different incentives to a publicly listed company. Those incentives shape decisions about pricing, data use, and what gets prioritized when commercial interests and safety interests conflict. Second, what they want from your data. Training AI models requires enormous amounts of data. Your inputs, your prompts, your documents, your questions may be part of that pipeline unless you have a specific commercial agreement that says otherwise. Under POPIA, if you are inputting client information into a third-party AI tool, you are the responsible party. That obligation does not transfer to the tool provider. It stays with you. Third, whether their mission aligns with yours. Some companies are focused on safety, some are focused on market dominance, some are both, in tension with each other. Knowing where a company sits on that spectrum helps you evaluate how much to trust their product and their terms. Let us start with the 2 companies whose products you are most likely to use directly. OpenAI was founded in 2015 as a nonprofit. In 2019, it created a capped profit subsidiary to allow it to raise capital. In 2025, it restructured again as a public benefit company, removing the profit cap entirely. Microsoft has committed approximately $13 billion to OpenAI. Sam Altman is the CEO. He was famously fired and rehired within days in November 2023. OpenAI makes ChatGPT and the GPT-4 family. The opinion flag? Critics argue the 2025 restructure marks a full departure from the founding nonprofit mission, despite OpenAI retaining a nonprofit board with oversight. That debate is ongoing. Anthropic was founded in 2021 by Dario and Daniela Amodei, both previously at OpenAI. They left to build a company where AI safety research was the primary focus. Anthropic is backed by Amazon and Google. It makes Claude, strong at long-form analysis and nuanced reasoning, both of which matter for legal work. 3 more companies worth understanding. Google published the Transformer paper in 2017, the technical foundation that every major language model runs on today. They make Gemini, which is integrated into Google Workspace. If your firm uses Google Docs, Gmail, or Drive, Gemini is likely already available to you. They also make Notebook LM, which is useful for analyzing large documents. Microsoft invested approximately $13 billion into OpenAI and integrated GPT models into Office 365 as Copilot, Word, Outlook, Teams. This is the most likely route through which AI enters a traditional law firm without anyone making a deliberate adoption decision. If your firm is on Microsoft 365, Copilot is either already there or coming. NVIDIA did not build AI. They built the hardware that makes AI possible. GPU chips originally designed for gaming turned out to be ideal for AI training at scale. Jensen Huang's company went from a market cap of around $3 billion to over $100 billion in 2 years. Infrastructure wealth is not the same as AI policy influence, but it is worth knowing who profits from the AI boom regardless of which model wins. Let me give you a clear picture of the landscape in one place. OpenAI makes ChatGPT and GPT-4 public benefit company as of 2025. Anthropic makes Claude independent, backed by Amazon and Google. Google makes Gemini and Notebook LM, public company under Alphabet. Microsoft makes Copilot, powered by OpenAI, public company. Meta makes Llama, which is open source, public company. Mistral makes the Mistral family of models, independent European company. The Meta point deserves a specific note for South African practitioners. Because Llama is open source, you can run a version of it locally, on your own server, without sending data to a third party. For POPIA compliance when processing client information, this is a meaningful option worth knowing about. Now, the tools themselves. There are hundreds of AI products marketed to lawyers. Most of them do one of 6 things. Category 1. General-purpose language models. ChatGPT, Claude, Gemini. Not built for law specifically. Useful for drafting, summarizing, and research. Limitation. No South African law grounding, no access to your matter files, and a real risk of fabricated case citations. Category 2. Legal research tools. Westlaw AI, LexisNexis, VLex. Built on verified legal databases. More reliable because outputs are grounded in actual sources. VLex has South African content. Westlaw and LexisNexis have limited SA coverage. Category 3. Document review and contract analysis. Kira, Luminance, Spellbook. Extracts clauses, flags deviations, compares versions. Used heavily in due diligence and commercial work. Category 4. Drafting assistance. This is where Harvey sits. Legal-specific AI built for law firm workflows. I will give Harvey its own slide. Category 5. Practice management and billing. AI embedded in operations, time recording, invoice generation, matter management. This is where KZ fits, and we cover that in Module 5. Category 6. Specialized tools. Built for a specific area. IP, family law, immigration. Narrower in scope, but often more reliable because they operate within a defined domain. Harvey deserves more than a line in a list. Harvey was co-founded in 2022 by Winston Weinberg, a securities and antitrust litigator, and Gabriel Pereira, an AI researcher from Google DeepMind. It was built specifically for legal work, not adapted from a general model. It now runs on Harvey's own legal AI infrastructure. The signal moment came in February 2023 when Allen and Overy announced a firm-wide deployment. Not a pilot, a position statement. PwC Legal followed. McFarland's, CMS, 7,000 lawyers across 50 countries. More than half of the AmLaw 100 now use Harvey. Why did that matter? Because Allen and Overy's adoption communicated something no technology company could communicate on its own. It collapsed the permission barrier. If a Magic Circle firm trusts it publicly, smaller firms can evaluate it without embarrassment. What Harvey does? It drafts and reviews contracts, runs due diligence across document bundles, generates research memos, and works inside Word and existing systems. The South African caveat: Harvey's training is weighted towards US and UK law. No South African firm partnerships have been confirmed as of mid-2025. Test it against SA-specific scenarios before relying on the output. Harvey is valued at approximately $8 billion as of December 2025, which tells you how fast this market is moving. Before we close, a direct word on your obligations. You are not dealing with neutral infrastructure when you use an AI tool. These are commercial relationships with specific terms, and under South African law, those terms do not absorb your professional obligations. POPIA Section 21 is the relevant provision. When you input client information into a third-party AI tool, that tool becomes an operator. You remain the responsible party. The compliance obligation does not transfer, it stays with you. 3 questions to ask before using any tool with client data. First, are my inputs used to train their model? Second, where is my data stored and for how long? Third, what happens to my data if I cancel? On professional privilege, whether current AI terms of service adequately protect legal professional privilege under South African law is not settled. There is no binding judicial or regulatory guidance as of mid-2025. The conservative approach is to avoid inputting privileged client communications into any third-party AI tool until clearer guidance emerges. You now know who built the tools, what structures they operate under, what the 6 categories of legal AI tools are, and what your obligations are as a South African practitioner. In the next module, we move from theory to practice. We are going to look at AI working in real time, what a good prompt looks like, how to structure your requests, and what the tools actually do when you put them in front of legal work.